What does it mean when a defendant pleads guilty or not guilty? Is it the same as saying that the person is innocent or not? When someone is charged with a crime and is brought before the court, he is asked by the court, "How do you plead?" This is a question that has more legal implications than a reflection of whether the person is admitting to the wrongdoing. But first, let's go back to the usual process of being charged with a crime. When someone is seen by the police committing a crime, the police officer will either arrest the individual or issue a summons for them to appear in court and answer to their alleged crime. For more serious crimes, a person will more likely be arrested than let go on a summons. But being charged with a crime doesn't mean that the process is over. In Canada, as well as other Western countries, a person who is accused of a crime has the right to be presumed innocent until it is proven that he is guilty. In Canada, this right is protected under Section 11D of the Canadian Charter of Rights and Freedoms, which is a part of the Constitution of Canada. Even in cases where the person's guilt is so obvious, that presumption must be afforded to the accused, even if it comes at a great cost to the state. The reason why that presumption exists is because the court is aware that there is a power imbalance between the parties. The Crown Prosecutor has all the tools and wealth of the state at his disposal. The automatic trust factor, trusted experts, well-paid and highly trained lawyers, and in some cases, even big labs that can do any kind of testing the prosecutor needs. To help balance that imbalance, the court assumes that the accused is innocent and puts the burden of proving guilt on the state. And since there is a presumption of innocence, the court requires a lot of evidence to shake that presumption. The state has to prove its case beyond reasonable doubt. How high of a level is that? Take a look at this picture. If you find yourself saying that the accused person probably committed the crime, that is not good enough for the charge to stick. The Crown Prosecutor has a big job to show evidence that rises up all these steps to make an almost certain case against the accused. Therefore, when someone is accused of a crime, the court must look at the person as innocent, but give the state an opportunity to prove the defendant's guilt, especially if there is evidence that the accused may have broken the law. So when the defendant is asked, "How do you plead?" this is a legal question. The court is asking whether the defendant agrees that the state would have enough evidence to convict him of that particular crime. And that's the most important part of the equation. Is the defendant guilty of the crime they're charged with? The reason why that's so important is because it can make a huge difference in terms of punishments faced. For example, if someone is charged with manslaughter, they could face a minimum of 4 years to a maximum of life imprisonment. Yet, if they are charged with first-degree murder, they're facing a minimum of life imprisonment. Let's take a look at an example to better demonstrate this point. Let's imagine that Steve was out at a bar one night and had a few drinks. While at the bar, he gets into an argument with another person at the bar and they start fighting. Steve punches this person so hard, he ends up hitting his head on a nearby chair, causing him a fatal head injury that leads to that person dying. Steve is arrested by the police and charged with several crimes, including first-degree murder. That is, that Steve intended to kill the person. Steve may end up pleading not guilty to that particular charge for a number of reasons. First, if convicted of first-degree murder, he may end up facing a life prison sentence, the harshest punishment available under Canadian law. Second, he may disagree with the allegation made against him. He may admit that he hit the person in the bar, and may even admit that he meant to cause him harm, but he will likely deny that he had the intention of killing him. If Steve pleads not guilty to the charge of first-degree murder, then he is telling the court that he is not convinced that the state would have enough evidence to show that he intended to murder this person. This would force the state to make the decision of whether it should proceed with that charge and prove intent at trial, or simply drop the charge and focus on the evidence that it does have. The decision for someone to plead guilty or not guilty is not a light one, and should be done only after consulting with a lawyer. Courts go to great lengths to make sure that the accused has a lawyer representing them, or at least is understanding what they are pleading to. So next time you hear that someone has pled not guilty to a crime, instead of thinking, how can they deny they did this crime? Ask yourself, how will the prosecutor prove they did this crime? Thanks for watching. If you like our content, please make sure to hit the subscribe button and to follow our channel for the latest videos.